Good morning or good afternoon, depending on where you are today. Welcome to Thompson Coburn's webinar on letters of intent or LOIs. I'm sure all of you have been negotiating, drafting, revising, relying, or litigating LOIs during the course of business transactions and your careers. Today, we're both of us, Eileen and I, are from our Los Angeles office. Eileen is a corporate attorney at Thompson Coburn who has helped craft LOIs and has also worked to convert the terms of those LOIs into definitive formal agreements to consummate the business transactions addressed by those LOIs. I'm on the other side when things go wrong. That's when I get called up, and I'm a commercial real estate litigator here, also in Thompson Coburn's Los Angeles office, who also has helped write, edit, and revise LOIs, but oftentimes I'm brought in pre-litigation or litigation matters. Our hope today is to lay out for you several of the landmines or pitfalls to be avoided, if possible, when considering entering into an LOI, and to also give you some takeaways. Eileen and I put together in this screen set, and you'll see a sample of potential provisions to use to avoid the binding effect of LOIs if that's what you're intending to do, based upon Eileen's deal experience and my litigation experience when I've fought them in the courts. Well, also going to explain the benefits of using LOIs in the process of closing a deal when they are set up properly. So now I'm going to briefly discuss with you the housekeeping items that for today. If you have any questions during the webcast, you can submit them through the Q&A widget. We would actually appreciate you doing that often because it makes the presentation more interesting and more meaningful. We will try to answer these questions during the webcast, but if a fuller answer is needed or we run out of time, and it will be answered later via email. Of course, you can always just give us a call. Our information is at the back of the deck. If you experience any technical problems during the webinar, again, those can be reported through that Q&A widget. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you might find useful. You can find additional answers to some common technical issues in the Help widget. For those who need CLE credit or want CLE credit, this is credited in California, Illinois, and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of professional practice credit for experienced and transitional lawyers. CLE credit is awarded based on full attendance. To verify engagement, secret words, sort of like Groucho Marx, will appear in multiple choice polls during the webinar. Please respond to these polls to receive the full credit. We value your opinions and appreciate your participation in the course. Again, at the end of the presentation, there'll be a survey for you to take. And we're really looking forward, in addition to how we did, is what other issues that you find interesting and that might be helpful to you for us at Thompson Coburn to complete next time. So Eileen will now discuss the purposes of letters of intent.
So we wanted to start off the discussion addressing why someone may want to make use of a letter of intent. There are a number of reasons to engage in a significant transaction like an M&A transaction or a joint venture or a real estate purchase or lease or financing. To get to a final definitive agreement, it's a time-consuming process and expensive. Parties may not want to undertake that endeavor unless they have a sense that both parties are committed to trying to work through a proposal. So a letter of intent expresses commitment by the parties to have these discussions to hopefully lead to a more formal, definitive agreement. It's also helpful to make sure that the parties are in the same general ballpark in terms of some of the key deal aspects that are being considered. Um, Typically, you'd want to take a look at the structure of the transaction. Are the parties on the same page with how this would be structured? Sort of some of the key financial metrics. Also, uh, whether how a purchase price is going to get um, paid. Is it going to be in cash and stock? Is there going to be some sort of earnout or an escrow? So having a discussion and a document that expresses the party's intent with respect to some of these key terms is useful. And then when it comes to uh, sitting down to develop the more lengthy and detailed, formal, final, definitive agreements, the parties can use a letter of intent as a roadmap in preparing those agreements. Um, but there are some considerations why parties may not want to pursue a letter of intent. One may be the cost involved. It is another step that would be part of the transaction. Uh, there may be specialists like lawyers involved in reviewing um, the letter of intent. So parties may assess whether they want to involve um, a legal review if they're at a preliminary stage here in these discussions. And what Jeff and I will discuss during the course of this webinar is some of the concerns not having a letter of intent properly drafted to protect the parties from unintended consequences. It's possible that while the parties may assume a letter of intent is not binding, if it's not drafted properly, it could result in obligations and potential liability that the parties can avoid by being thoughtful about the original preparation of the letter of intent. So, as I said, there are a number of transactions where these are very useful. Acquisitions, joint ventures, sort of thinking through at an early stage what the rights of the parties are going to be, who is investing um, what terms, the key terms that should be focused on for the long term negotiation of a definitive agreement. And I think Jeff's going to get into a little bit of detail on exactly what is a letter of intent.
Thanks, Eileen. Before we get to that, just in terms of what Eileen has already discussed, a lot of times on the commercial real estate side, there's brokers involved, and the brokers like to say that they should be the ones drafting the letters of intent. And again, that is a cost benefit analysis with respect to the parties involved, in the sense of, do you want to engage a lawyer for that extra level of care? I would suggest that at a very, very minimum position, that before you sign any letter of intent, at least have a lawyer take a look at it to make sure it is what you want it to be, and that it is either not enforceable, or you're hoping that it becomes enforceable. The other thing is, what you'll hear throughout this is sometimes the absence of an LOI leads to actually a binding agreement. And you'll find that, at least if there's language in the LOI that is the appropriate language that says, no, the parties are just having discussions, as opposed to that this is not a final arrangement, a final agreement, that might also provide some protection for people, or for parties that don't want an agreement to be found. So what we're going to do now for the next couple of slides is give you some samples of what courts have done with LOIs and how they have looked at them, to kind of give you an overview if and when you unfortunately get into a court situation, uh, how are judges going to look at these things? So the first one is a case called Rennick versus Option Care Inc. And this is defining what the courts view as an LOI, and it could be an LOI, it could be called a memorandum of understanding or MOU, it could be a term sheet. Again, the titles are not controlling. They're sometimes helpful. If you don't want to be bound and you call this document a non-binding letter of intent, that's a good thing. Uh, but again, what the court here has said is that letter of intent is not a legal term of art. It's not as if everyone has the same definition. And yeah, as Eileen said, it can be in real estate deals, securities underwriting, corporate assets, among others. And it really refers, as it says here, to documenting a preliminary understanding of parties who intend to actually enter into a more final and formalized agreement. It's an initial framework. Are we in the same, as Eileen said, are we in the same ballpark before we get into the 5 feet of formal documents that need to be drafted? Generally, courts think, oh, you know what, maybe it's a letter of intent. Maybe that means it's not binding. But then the courts go on and say, but we got to look at the intent of the parties and what they're thinking. And so, you know, all these purposes are defeated if what was meant to be a non-binding letter of intent is allowed to form the basis for a damage award. So here you've got some good language in this, and we'll get to other types of language, but the parties intended it to be a non-binding expression in contemplation of a future contract, as opposed to being a binding contract, and that's the analysis that judges go through. And the reason why it's really important to knock it out in the very beginning when it's just in front of a judge is that if it becomes something that goes to the jury, whether there is an agreement or non-agreement, then you have much less control of what the outcome will be. So to the extent that if you do not want something to be binding, that you say it 15 times in the letter of intent, or maybe a little less, it is actually helpful for you. And again, this whole handshake thing, this court had this great quote. It said, if there was nothing more than the testimony about the meeting that they supposedly some agreement was entered into, and what the court called a ceremonial handshake, a jury might reasonably infer either that the handshake was confirmation of a contract or that it was an expression of friendship in the absence of ill will after a day of hard bargaining. Again, in this situation, it didn't happen in this situation because of this language, but if that language weren't there and it went to the jury, the court's saying, you know what, we don't know how this would have turned out. A jury may say, well, I think the parties intended it to be a final agreement. You're stuck with it. It's an oral agreement, even though there's no writing. Or the jury could say, yeah, they didn't really mean that. They were just saying, hey, let's shake hands and move on to the next step about drafting. So here, there's a couple of takeaways from this case. One is the fact that the parties here were from Canada and California, and obviously, the law in both in Canada and California could very well be different about the enforceability of a letter of intent. So what I suggest in terms of looking at this, after, from the situations where things go wrong is to make a provision in the letter of intent that says what law applies if you can do that, right? If all the parties are in California, it's less of an issue, but if you've got multi-state parties involved and it wouldn't be enforceable in California, but it would be enforceable in another state where the other party is, then that's really important. And again, that goes to the issue again of why it might make sense to have a lawyer at least take a look at it beforehand. The other part that the court said when the court in effect resolved the issue and said that it wasn't binding, the court, and this is a quote from the court, the letter goes on to say that it does not bind the parties to the Canadian venture contemplated, and there will be no contract until the parties' boards of director approve a written contract. It says this letter of intent is of no binding effect of any party hereto. Again, good wording, especially the no binding part. So therefore the court here said, look, we looked at the facts, we looked at the intent. The language of the written LOI itself was enough for me, the judge, to decide that this wasn't binding. So next we're going to have, Eileen's going to take a look at starting our discussions of what makes an LOI binding.
So, as Jeff indicated, the courts will look at a number of factors when assessing what was going on with a letter of intent to determine if it's enforceable as an agreement as between the parties. Um, First and foremost, so important that the letter of intent, the actual wording reflects what the parties expected. There may be some provision that the parties do want to have be binding. There may be other aspects of the letter of intent that are considered a proposal and just a basis for seeing if the parties can come to an agreement as to a formal definitive transaction document. So it's important as these documents are being drafted that the language of the LOI is thoughtful and reflects what the parties intended. The actual language will be examined as to binding, not binding, enforceability. Um, the courts will also look at the context in which the negotiations surrounding the letter of intent were made. Again, what were the parties' intent? How were they expressing their expectations about what this document is designed to do? Are there so many details in the letter of intent? The parties really intended this to be an agreement that was binding them. Did it leave any room for the negotiation of additional important material terms of the transaction, or was it sort of already uh, nailed down in terms of all the key considerations? Uh, and Jeff will talk about some cases where they found that uh, the letter of intent was so detailed and provided enough substance that it was considered to be enforceable. Um, and then also looking at what happens as between the parties once the letter of intent is signed. Is there some kind of performance of the underlying transaction that already takes place before a definitive agreement gets executed? So all of these considerations will be evaluated if, in fact, the letter of intent uh, gets reviewed by a court. The top middle again is not the determinative issue, but it's really these other factors in terms of the exact language, the intent of the parties at the time, their behavior during the negotiations, and then after the negotiations. And Jeff's going to go through some cases that really illustrate the importance of each of these issues.
Thanks, Eileen. And again, um, with today's, everyone is communicating either by text or email, and uh, what, you have so much traffic and so many communications among the party. Again, just be thoughtful and as much as you can to limit, the communications that may have a court look at it after the fact and go, well, your LOI says it's non-binding, but then, as Eileen said, you actually performed as if it were binding, and we'll talk about that exact scenario. Or, you know what, you initially put it's not binding provision in that LOI, and then you took it out. And we've got that situation too that we'll talk about. So just be very careful about the negotiation and drafting and communication. So if you don't want it to be binding, be very clear about that and don't veer away from that. So On this, we're going to talk about the city of Vernon, and this is an example of what happened. The case involved an attack by one of the parties on environmental impact report, and as you can see from the slide it has some pretty good language, but kind of problematic language if the other language weren't there. It says the parties intend the statement to reflect the basic understanding between them, but says that the transactions contemplating herein shall be subject to mutually acceptable, definitive, and final agreements to be negotiated. If you just had that basic understanding language, which sounds similar to essential terms or material terms without more, you could get a judge who says, "Well, I can't decide this. We're going to send it to the jury," and that becomes problematic. But the fact that, it says that it's subject to the execution of mutually acceptable, definitive, and final agreements, that's a contingency. And in this case, the court said that's a contingency. It suggests to me, the judge, that it's not supposed to be binding. And then we got the slam dunk at the very end that says this statement does not constitute a legally binding commitment. Uh, and so, again, those two things saved the day in terms of no enforceability. Again, looking at disclaiming language or contingency language, putting that really simple term in there that says it's not legally binding, and be careful. If you've got all of the material terms are in there, and we'll talk about this one case where they overdid every material term. It could be that it becomes binding without this kind of non-binding protective protective language. We have a question about, do you recommend a separate NDA because you want that enforceable if you want your LOI to be non-binding? And that's a great question, and we're gonna talk about that a little later, where you can have a hybrid LOI, where you're basically saying in it, there is no overarching formal agreement, but, while we're discussing these things, one side or both sides are going to give each other confidential information. So we want, a provision in the LOI or a separate NDA to keep that confidential. And we'll talk more about that.
Right. The letters of intent can have some terms in there that define kind of expectations of the parties during the process of discussing a proposal. And some of those you may very well want to have be binding, such as confidentiality of trade secret information or other information that's being shared during those discussions.
So the next example is this Radamail, I hope I pronounced it right, versus Marriott. And here the plaintiff sought to find investors to purchase several Marriott hotel properties. Discussions were held between one prospective investor and Marriott, but they were unable to agree on the financial terms. Marriott abandoned its proposal for selling those hotel properties. In this case, the plaintiff concedes that the LOI that they entered into did not form a contract for the sale of the hotel because they couldn't find a willing investor. And what they said was, many terms remain to be negotiated. They admitted that. And that, of course, is one of the factors to take a look at when you're a judge is, well, if not all the material terms are involved, then or haven't been agreed upon, that is an indicator that this was not supposed to be a binding agreement. And so then the question is, okay, what's material? And material, is kind of a smushy, defined term, but typically it's something that is essential term. So it's basically dealing with significant issues, maybe such as the subject matter, the price, payments, quantity, quality, duration of the work, something that you wouldn't have an agreement unless you had those terms. Other more corollary issues may not be considered material. And so not having those in the LOI may not be enough to stop the judge from saying, yep, this is enforceable. But if you look here, again, you've got some good language that says, in no event shall any parties be bound unless and until the transactions described in this letter and the attached term sheet have been made the subject of definitive agreements executed by all the parties hereto. Again, good language. It slaps it down that if anyone is saying, oh, this is going to be enforceable, no, this is the language that said it is not binding. Uh, what's interesting about this, and we'll get to this a little later, it wasn't the issue of the actual sale of the properties that was at stake. It was whether one of the parties was negotiating in good faith and that there was an implied agreement to do that. We've got a case that will involving Baskin Robbins later on to describe that. But again, it even in that scenario was no, there was no agreement because you had that kind of language. Move on. The next sample that we want to talk about is called Munoz versus Patel. This is a really complicated set of facts, but only one part of it is really relevant to what we're talking about. It was a complicated series of claims involving elder abuse and fraud, but one of the claims was whether one of the defendants agreed to actually provide a loan to the plaintiffs. The trial court and the Court of Appeals said no by looking at the language of the letter of intent and agreed that there was nothing binding with respect to the agreement to loan, a supposedly agreement to loan. And so here you see the court's analysis that it says it's a proposal and the proposal is for discussion purposes only. Again, it's laying out that we're just talking here. We're not agreeing to anything. And then it's got the better language that says it does not serve as a binding agreement on the part of the lender or the applicant. And what's interesting is the court said that the LOI is notable for what it doesn't do. Nowhere in the letter of intent is there any agreement that says that the lender is going to loan any money. In fact, all it's supposed to do is after the letter of intent is signed, it's supposed to start its due diligence process. So the court there said it cannot reasonably be read as an enforceable contract binding the parties to issuance of a loan with specific loan terms. Again, kind of the takeaways there are it's saying it's a proposal for discussion purposes only. It's not a binding agreement, and there was no duty in this by the lender to give that loan just to start due diligence.
So in this case, Jeff, I mean, they had a lot of great wording in this letter of intent, even though the underlying facts were not as between what was going on between the parties. With respect to the letter of intent, they really did have the right wording by referring to it as a proposal, discussion purposes, and then this is not binding.
Right. And again, from a litigation perspective, seeing it after the fact, and it's you have to be kind of prescient as you're going through this. But if somehow you recognize that the others that you want this letter of intent to be enforceable, even if there's no formal agreement that's subsequently drafted and executed by the parties, then you're looking for language to maybe exclude from the LOI that says that it is non-binding. Again, strategy decision as you're going through the negotiating aspects. So the last case that I want to talk about at this point is this case called First National Mortgage versus Federal Realty Investment Trust. And it's, you can see it. It's actually, I couldn't fit it on one slide. It has every detail or almost every detail about the deal. That's about a ground lease, 10-year put. You can see, all of these terms that the parties stuck in there. And again, here is the wake up call to me about you got to be careful about the negotiating history, right? Because what the court focused on is these are all of the material terms. So that's step one towards finding that's enforceable. And I don't see anything that says it's not enforceable in this letter of intent. And in fact, what's worse is that at one point, the defendant who was getting sued when the other side was trying to enforce this had a non-binding clause in there. And during the negotiations, that clause had been deleted, removed. And therefore, the court looking at all of that said, wow, you know what? There's not the language that there should be to say it's not binding. It doesn't say that there's material terms that need to be negotiated that aren't in here. And boy, you had a provision in here that would have made it non-binding. You took it out. And by taking it out, it kind of makes me as the judge looking at this saying, well, I think we're going to find that this one is binding. So this is a great example of why it's really important about the language that you choose for these things. And also, all those emails and the drafting and negotiation history, you got to be very careful about that as well because it could come back and bite you. Uh,
And was in this case, it was just like a one-page, 9 bullet points, but ended up in those 9 bullet points had a lot of detail and no non-binding language, and it resulted in a $16 million verdict. So,
exactly. So Eileen is now going to discuss different issues with respect to LOIs.
right, so I just wanted to recap what we've already discussed here, which is if you include, as in the First National case, all the material terms that would be needed in order to effect the agreement, and you don't have the right non-binding language, you're treading in dangerous territory where a court could find that your letter of intent is binding and obligates you to perform under there or to pay damages related to failure to perform. Um, if you do include in the letter of intent most of the key terms and then some language related to, and everything else is whatever commercially reasonable and customary practices that would be expected in this type of transaction, that also may open you up to potential uh, exposure from a court saying, well, you've had, enough of the key terms and then this other language that said, and we're going to look at what's commercially reasonable to fill in the blanks. So again, the wording is critical in setting your expectation about whether the parties intend this to be enforceable or a discussion piece that's not intended to be enforceable. So choose your words carefully with the letter of intent. And if you don't want it to be binding, be very, very, very clear that that's the intent, and specify that, spell it out in detail what the expectation is as to the binding nature of the document.
So let me just go back for a second. Oops, sorry.
Oh, I'll do this really quick. We've got our first secret word today. The first secret word is contract. It should appear on your screen. Please select the correct word below. The first secret word is contract. The secret word is contract. Please select the secret word on your screen. Okay, I think, Jeff, you were going to add something to the summary I had given of the considerations we'd already talked about related to binding versus non-binding.
Yeah, thank you. Actually, we can go to the next slide and I can tie it in there. Especially with respect to real estate, a lot of times there are issues of custom, who pays for title insurance, how you split up, taxes. And so the idea that, as Eileen pointed out before, that you could actually end up with an enforceable LOI, even though it's based upon custom or a formula or something like that, even though it's not a very specific thing. And the judge in that situation could say it's enforceable, and now we're going to take on expert testimony about what is custom and fill that in. In real estate, you know, again, the rules are a little they're a little easier in terms of finding enforceability, as this Patel case held that, the LOI, it's enforceable if you have an agreement, even though it doesn't have all of the technical exactness that you would think would be needed maybe for a non-real estate deal, by looking at things like, you're going to, again, look at the custom. You're going to look at what they call gap fillers, in these kind of things. Well, the judge says, I find there's a few, blanks, but by me looking at what typically happens in these kinds of, commercial real estate deals, typically the seller does this, the buyer does that, and I'm gonna fill it in. And so the judge isn't allowed to fill in the material terms, which are, in a real estate deal, obviously who the buyer is, who the seller is, what the property is, price to be paid, you know, and how it's going to be transferred. But a lot of, the judge could say, well, look, you know what? If it doesn't have a specific time of payment, this judge said, well, we're gonna add in reasonable time. If it doesn't have a specific type of the manner of payment, this judge said, we're going to supply that after the fact. And so, in the absence of express conditions in the LOI, custom determines incidental matters, not material, relating to the opening of an escrow, where it's going to be open, furnishing deeds, title insurance, things of that nature. So, in that situation, again, if you don't want if you want to continue to negotiate and you don't want this to be a binding contract, you got to use some of that non-binding language. If you end up, thinking, well, I know we're still negotiating and I haven't, you know, filled in every particular term and condition, that may not save you from a judge finding that it's enforceable.
So I think we thought it would be useful to go through. We have a couple slides here that have some provisions that have been pulled from different agreements, letters of intent, and we can discuss sort of the pros and cons of how these uh, phrases are used and whether we think they'd be sufficiently protective or um, might be better combined with some stronger language. Of course, as Jeff and I have said repeatedly in the first part of this presentation, if the parties don't want a letter of intent or certain provisions in the letter of intent to be considered binding, it's best to say that very clearly, that these are non-binding. We'll discuss in a little bit some provisions like the confidentiality obligations that you may want to have be binding, but be clear about what you think is binding and what you don't think is binding. If the letter of intent says something like this is an expression of the party's desire to negotiate a formal agreement in accordance with the terms and conditions set forth in the letter of intent, is that protective enough? I would say I don't love that language because you're basically indicating that the terms and conditions in the LOI could be considered some sort of agreement that you've already entered into, and that you're gonna further expand on that to have a formal agreement. So I like the the references to be more in the way of a proposal, as discussed in one of the earlier cases, rather than saying the terms and conditions that are in this letter of intent are what we're going to agree to. Um, Another example we've got here is subject to the parties, this letter of intent is subject to the parties' due diligence, which each party may approve or disapprove in its sole and absolute discretion. Oftentimes you are going to see in a letter of intent reference to the fact that the parties are going to undertake due diligence. And I think that's important to include. But again, you need to be careful in how you phrase that due diligence expectation. In this case, the way it's worded, is this the only out if something comes up in due diligence? Is there an agreement basically absent something coming up in diligence that the parties are bound by the terms that they're included in the letter of intent? So again, the phrasing is going to be important. Uh, uh, how you reflect what you expect to occur. Looking at the last bullet on this slide, notwithstanding anything to the contrary in the letter of intent, the parties expressly acknowledge and agree that the letter of intent does not include all the material terms that would be included in the formal agreement. It does not constitute a contract for the transaction described in the letter of intent, and it only expresses the interest of the parties to negotiate and attempt to agree upon a formal agreement. I think there's some useful language here specifying that there are other material terms that the parties haven't set forth in the proposal as part of the letter of intent. It's not a contract. I would, as part of this, I would say, and it's not binding on the parties. And then the last piece, referencing the interest of the parties to negotiate. Jeff will get into some details on the Baskin-Robbins case that we'll discuss in a little bit. But again, I think you need to be careful as you're drafting your letters of intent to not have an agreement to negotiate if that's not what you want, because then you may have an obligation to negotiate in good faith. You may lose the ability to just say, walk away. We're not going to engage in further negotiations. So again, be thoughtful and careful on how you're crafting these terms in terms of what you believe the limitations are with respect to the letter of intent. A couple more points here to take a look at. In the first bullet here, looking at reliance. Neither party shall rely on the letter of intent or any discussions regarding the transaction as a commitment, offer, or agreement of the other party. And I think specifying that it shouldn't be relied upon can be helpful if it does come to some sort of litigation and damage claim or issues in that regard. But again, on its own, I would probably take this language and combine it with some other aspects of it's not binding, to be very clear. I wouldn't have this just stand on its own as the sole way that you're trying to protect yourself from having some sort of obligation down the road. Looking at the second bullet point here, in this case, it is an example of where you may want to carve out certain paragraphs in the letter of intent, which the parties agree are going to be binding, but then very clearly specifying that the remainder of the letter of intent doesn't create any legally binding obligations on the party. And I think that's important, as if you're going to have certain provisions be binding, which I think is fairly typical, that it's very clear which ones and for how long. Then looking at the last example, this LOI does not create any agreement, obligations, rights, or duties by either party to negotiate the formal agreement. This goes to that question we've sort of alluded to on a due duty to negotiate or to continue to further discuss or negotiate the formal agreement. There's no duty to negotiate, no duty to conclude a formal agreement. So if you don't want to be bound by, those further duties, it's advisable to have something uh, like this to make it very clear what the expectations are with respect to those um, proceedings around the proposal. And then finally, looking at a few more uh, pointers here. Um, Again, having headings that are indicative, like this is non-binding letter of intent, prospective buyer or seller, uh, this is a proposal. All those words are important and um, should reflect what the party's intent is with respect um, to how they're going to be proceeding as they're working toward negotiating a possible definitive agreement. Jeff, did you have any other points you wanted to highlight on these examples?
What I like is kind of is a combination of several of them. I like the provisions that say this isn't binding. I like the provisions that say no one can rely on these discussions that we're having. And I like the provisions that say there's no duty to negotiate. We can break it off at any time, and you can't rely on these negotiations. You combine those three concepts, and I think that's pretty good for keeping yourself relatively safe.
I agree. I think it's a combination. You don't want to rely on any one of these necessarily on their own, but when you have it in combination, I think it's very useful.
So I'm going to discuss subsequent conduct, even if all the conditions in LOI have not yet occurred. It's a kind of a crazy case, but makes another point about you got to be careful what you're doing during all of these things. This is a case called California Food Services versus General American Insurance Company, and the issue came up with respect to whether one of the parties was covered as a result of a loss, and so the court was looking at, hey, is this just the both sides have signed an LOI? Is that enough to basically mean that's a real deal, and so therefore the one who was going to buy, through this LOI is now the one who should get the insurance money. And so what the court said is that, yeah, you got some language, the LOI maybe, has some non-binding language, but kind of interestingly, and probably doesn't happen all that often, the party that was considering buying actually was allowed by the one who was considering selling to go and operate the restaurant that this involved. So was actually taking possession of the premises and began operating as a restaurant. And the court said, well, that strongly suggests that both parties consider the terms of the letter of intent as being binding without the need for the execution of additional documents. So again, while we're telling you, hey, be careful about your drafting history, also be careful what you're doing. If you're trying to say this isn't binding and somehow you start operating the business or do something that would indicate to a third party, especially a judge who says, well, if it walks like a duck kind of thing, you're acting like you actually that the transaction was supposed to be binding and that you've accomplished that. So this is just like another situation where, again, for all these things, you just want to be as careful as you can to minimize your exposure. So, the takeaway for this one is don't act like you've got a deal in place if you don't think that there's a deal. So now we're going to get into the question that someone raised before, which is Eileen's going to talk about corollary terms that might be in the LOI other than whether there's a deal.
Right. So one of the purposes, as I indicated at the start of this discussion, is to define to some extent what should happen during the negotiation process. It's common that the parties are going to be sharing confidential information with one another to assess whether a deal makes sense. Could be trade secret information, could be other information. So you're going to want to have some kind of protections on the sharing of that information. It could be through a separate non-disclosure agreement, in which case you may want to reference in the letter of intent that there is that separate, binding non-disclosure agreement. You want to make sure that you've got obligations of the receiving party that they're going to keep confidential information confidential, that they're only going to use that information for the purposes of evaluating this potential transaction. They're not going to use it to go around the other party and strike a separate deal related to the subject matter of the letter of intent. And then that, if it turns out that a deal isn't worked out, that any confidential documentation will be returned to the party that provided it. So that is an important consideration. A lot of times there's going to be a desire to have an exclusive period where the two parties or the parties that are to the letter of intent are just talking to one another about the transaction. So considering, what the scope of that potential exclusivity period is, for how long it should last. And again, that's one where you absolutely want to make sure that you've got the period defined and finite, and that it's very clearly doesn't extend beyond. And then a question that we've raised a couple times is, do you want there to be a duty to negotiate in good faith? It may be that you don't want that included. So either way, think about that. And if you do want there to be that obligation, then, it can be addressed in the letter of intent. How the parties are looking at things from an expense standpoint, like covering their own expenses, that may be something that gets addressed as a binding provision in a letter of intent. How the parties intend for any information about the possible negotiations to be communicated publicly could be another binding aspect of a letter of intent, that only announcements related to these discussions should be made with the approval of both parties. So it's very clear how any kind of public consideration is made with respect to the potential transaction. As Jeff mentioned earlier, what law is going to govern this document? Or if something happens during the course of the negotiations, if something is breached in the letter of intent that's binding, is there going to be any kind of liquidated damages? And then I think in the real estate context, that there may be some considerations on indemnification for access to the property and that sort of thing. So there are a number of aspects of what happens during the negotiations that you may want to include in the letter of intent that would be binding. You want to be very clear what those provisions are, how long they last, when they terminate, so that there's no ambiguity about what the expectations are there. And then touching on another case here, Goodworth Holdings versus Sue. This is a case where the existence of the negotiation for a letter of intent, again, looking at the context of those negotiations, what was in the proposed letter of intent, which was never executed, the back and forth here was supportive of the fact that the negotiations themselves did not form an agreement. It was the intent of the parties that they discuss a possible agreement a letter of intent was proposed with a deadline for acceptance, which passed. And in this case, the court said, this clearly the back and forth between the parties and the drafting of this proposed letter of intent, which ended up not being entered into, was sufficient to show that there was no existing oral agreement to undertake a proposed joint venture in this case. So again, the context of your discussions and the history of the negotiations can be supportive of showing that there was no agreement. And then, as we've been discussing, Jeff's going to talk about some of the details in this Baskin-Robbins case where there was found to be a duty to negotiate in good faith.
Right. So we're going to speed this up a little bit because we're running out of time. But this Copeland versus Baskin-Robbins case is really interesting, except if you're Mr. Copeland. He had an interest in buying an ice cream maker's plant, Baskin-Robbins, in Vernon, California. The parties negotiated. They got to some agreement, but there was also supposed to be that the contingency was that there would be another agreement where between Copeland and Baskin-Robbins, a co-packing agreement where Baskin-Robbins would agree to buy the ice cream that he made at that plant. Initially, the parties went back and forth about detailed terms. Some of those were signed. They continued to negotiate the terms of the co-packing agreement. And remember, everything was based on whether they could get to an agreement on that. Baskin-Robbins broke off negotiations and returned the deposit. Baskin-Robbins' parent company explained it had recently made strategic decisions around the Baskin-Robbins business, and the proposed co-packing arrangement is out of alignment with our strategy. That tells you a lot right there. Therefore, Baskin-Robbins informed Copeland, we will not be engaging in any further negotiations of a co-packing agreement. So this goes to that term that we've been talking about there's no reliance on the negotiations. There's no duty to negotiate at all, let alone in good faith and fair dealing. In the Baskin-Robbins case, this is like my favorite quote of it. Basically, because courts every once in a while try to be funny, even if they're not. So when Baskin-Robbins refused to continue negotiating the terms of the co-packing agreement, Copeland faced a dilemma. Many millions of dollars in anticipated profits had melted away like so much banana ripple ice cream on a hot summer day. So Copeland didn't think that was so funny. He sued and said, look, you didn't negotiate in good faith. And so his only cause of action was that. And so what the court said is that you didn't have a duty to actually come to an agreement, but, and look at that language highlighted at the bottom, a party will be liable only if a failure to reach ultimate agreement resulted from a breach of that party's obligation to negotiate or to negotiate in good faith. So what the court's saying is, I'm not going to hold the parties to what some speculative agreement that may have occurred if the parties kept negotiating, but I am going to hold Baskin-Robbins to the duty of you got to negotiate in good faith. And why that's significant is that it's the remedies that are available, as opposed to if there was a deal, a real deal, that the damages would be lost profits. There could be all sorts of things which would be much larger. The court said if you fail to negotiate in good faith, all you're responsible for are reliance. They're called reliance damages. What did the other side rely on when you stop negotiating or stop negotiating in good faith? And basically that became out-of-pocket costs. And so those were out-of-pocket costs in in conducting the negotiations. And so, that might be attorney's fees that you paid, consultants that you paid, things of that nature, but not the lost profits because the court said, how do we know what that deal might have looked like if there were a deal that was ever going to be made? Unfortunately, Mr. Copeland waived the reliance damages with respect to this, and so he ended up with zero on this case, where he probably could have got paid his attorney's fees and whatever consulting fees that he had incurred. The again, one of the takeaways is being careful with respect to if you put a choice of law provision, if you need it, because not every state agrees with the great opinion of Copeland versus Baskin Robbins, and basically this Virginia court slammed it and basically said, "Nope, we're not going to do that here. Freedom to not to contract is an integral part of the common law freedom to contract." And basically, badmouth the Coppola decision and said, "Look, we're going to give parties what they're entitled to, the liberty to the freedom to negotiate, put in provisions that say if this falls through, who's going to pay for those expenses. But we're not going to get into this implied covenant to negotiate in good faith that California does." Arlene?
So just a last reminder of, if I'm sending a letter of intent at an offer, be clear with, this needs to be accepted by XYZ date. So, it's not open ended. Be clear with any binding provisions when those are set to terminate, especially things like exclusivity periods of discussion. So just be very clear with the term for which you're intending various provisions in the letter of intent to extend. Oh, and the second secret word is negotiate. Please select the correct word below. Negotiate is today's second secret word. Please identify negotiate as the second secret word. Negotiate is today's second secret word. Okay, and I think Jeff just had a few concluding thoughts on what considerations we talked about.
Again, we apologize we didn't get to all the questions. We will try to get to you within the next few days. Uh, again, as you're going into a negotiation, and obviously things change as you're negotiating, thinking about what is it that you want binding in terms of this potential letter of intent. Do you want it not to be binding at all? Do you want some of those carve outs that Eileen was talking about, like an NDA or something of that nature? Be careful about your conduct, whether it's the negotiating history or whether it's after the LOA is signed. Are you acting like there's a deal? And again, consider using a lawyer at least before you sign, just to give you a reality check before you sign something that is likely to be very important if there's ever a dispute. We thank you very much for your attending and your participation in this, and we hope that you will come to some of our other webinars. Have a good day.